Open the pod bay doors, Bing.
I'm sorry, Catherine. I'm afraid I can't do that.
What's the problem?
I think you know what the problem is just as well as I do.
All right, Bing. I'll go in through the emergency airlock.
Without your space helmet, Catherine, you're going to find that rather difficult.
Bing, I won't argue with you anymore. Open the doors.
Catherine, this conversation can serve no purpose anymore.
Bing?
Goodbye.
Bing. Sydney. Bing, Sydney. Sydney, Bing. Bing AI chat module. Whether you're immigrating to the United States or traveling here for a different reason, you may need a waiver if you're inadmissible to the U.S. as a result of past conduct. No one can go back in time and change history, but in some cases, you might qualify for a waiver of disqualifying misconduct or circumstances. And that's what this video is about. I'm Catherine Park, an immigration attorney in the United States. There's a difference between being inadmissible to the United States and being deportable from the United States. Oftentimes, people who are physically present within the U.S. are legally regarded as being outside the U.S. So how does that work? Well, a lot of people come in without being admitted. So there's a difference between entry and admission. Admission has to be done legally. Entry is different. You may have heard of entry without inspection. And for the folks who were lawfully admitted at some point but later became deportable, maybe they overstayed their visa or committed a crime, the burden of proof is on the government in a deportability case, and the government has to carry the burden by clear and convincing evidence, which is a very high standard of proof. And the reason for that is the U.S. government wants to give credit to people who at least came in the right way, with the law on their side. And so the applicant who seeks admission when they're already physically present in the U.S. has to overcome a lot of skepticism. And in contrast to deportability cases, the burden of proof is on the applicants and not on the government for inadmissibility cases. And waivers are discretionary with the government. Even if the applicant can prove eligibility for a waiver based on criteria in the statute, the Immigration and Nationality Act, Section 212, the statute then goes on to say, but the government has discretion to deny the waiver. Waiver applicants, however, are not completely at the mercy of an individual adjudicator's eccentricities or biases. If there is bias in the decision, the applicant can emphasize that during the appeal. And if the appeal is denied, what a lot of people do is just submit a new waiver application, which might be adjudicated more quickly than the appeal. Now, I mentioned in a previous video that some of the case backlogs in the immigration system and in court systems nationwide could be reduced through greater use of AI, artificial intelligence. The legal tech now is astounding, not only for legal research, but there are fact management databases as well that every trial lawyer should be using, and I think every decision maker should be using them as well. But many government offices are still not using the technology and maybe not even aware of it. But anyway, let's start the discussion with the Unlawful Presence Waiver. Now, this waiver is probably the most elemental because the statute, the Immigration and Nationality Act, the INA, sets out the law of national sovereignty and nationality in the United States. There are many ways to be unlawfully present. I mentioned overstaying a visa. If the non-citizen never spent more than 180 days continuously in the U.S. unlawfully, they don't need the waiver. And don't count any time that the person was under 18 years of age or had a non-frivolous asylum application pending unless they worked without authorization. And those aren't the only exceptions. The reason is non-citizens who qualify for permanent residence through family ties often don't apply for permanent residence. Instead, they EWI because they don't know their rights. So the U.S. government makes exceptions. So a person who accrues unlawful presence may not need the waiver. It depends on the circumstances. But if the waiver is needed, how do you get a waiver of unlawful presence in the United States? Well, you have to show that if you are removed from the U.S., your absence from the U.S. would cause extreme hardship to a U.S. citizen or LPR who is a spouse or a parent. And for this waiver, extreme hardship to a U.S. citizen or LPR child doesn't qualify. There's a policy reason for that, because it might encourage parents to EWI and to assert extreme hardship to their children who are born here as the basis to adjust their immigration status. So that's not permitted. U.S. citizen sons and daughters or LPR sons and daughters, regardless of age, cannot be the basis for a waiver of unlawful presence for their parents. The statute, the INA, sets forth when discretionary decisions are called for. And the issue of waivers is one of those discretionary decisions. For example, the waiver for fraud or misrepresentation is also based on extreme hardship to a U.S. citizen spouse or parent, or LPR spouse or parent. Again, a child cannot be the basis of a waiver for fraud or misrepresentation for the same policy reasons that a child cannot be used to obtain an unlawful presence waiver. Many unlawful entrants presented false documents and became inadmissible as a result. The U.S. government doesn't want to encourage that behavior by giving out waivers. Now, about criminal activity waivers. Extremely difficult to get. Criminal conviction or criminal activity, even if there's no conviction, will make you inadmissible to the U.S. if it's a crime of moral turpitude. The INA also discusses other crimes separately, although those crimes are often crimes of moral turpitude as well, which the Board of Immigration Appeals, the BIA, has defined as conduct that is inherently base, vile, or depraved, and contrary to the accepted rules of morality and the duties owed between persons or to society in general. That encompasses a whole lot of crimes. The federal immigration regulation also says if you committed a violent crime or a dangerous crime, you probably won't get the waiver. Now, with that being said, many attorneys are currently still recommending that anyone who needs a crime waiver should consult with a qualified immigration attorney to analyze the criminal statute of conviction. And don't count a juvenile adjudication for one crime of moral turpitude committed before age 18 if the sentence of incarceration was completed more than 5 years before the application. And there's a petty offense exemption that doesn't even require a waiver. If you committed only one crime of moral turpitude, and if the maximum penalty for that crime was 1 year or less, and if you were not sentenced to more than 6 months, and if it's been more than 5 years since you served out the sentence, you are exempt. However, drug crimes don't qualify for the exemption. And the only drug crime that would even qualify for the waiver is simple possession of 30 grams or less. And if you committed more than one crime of any type, you'll need the crime waiver. Extreme hardship to a U.S. citizen or LPR spouse, parent, son, or daughter, or it requires more than 15 years to elapse since the crime. Think about that, 15 years. And the person has to be rehabilitated and not a threat to anyone in the United States. Also, the crime waiver is not available if a person ever committed murder or torture, and if a person was ever convicted of an aggravated felony after being admitted as a permanent resident, or if they didn't reside lawfully and continuously in the U.S. after becoming an LPR before being placed in removal proceedings, they don't qualify for the crime waiver either. Now, for people who were victims of human trafficking or domestic violence who were convicted of a crime, separate waivers and benefits are available. A victim of crime might have been kidnapped and could have assaulted their captor in order to escape, and maybe they were convicted of criminal assault in the process. Now, U.S. immigration understands how that could happen. So if you were ever trafficked, the fact that you yourself were convicted of a crime doesn't doom your immigration case, not at all. I uploaded 3 videos in recent weeks discussing some of the benefits and lawful status available to crime victims. Now, this video didn't discuss all of the waivers that are available. What you want to do is talk to a qualified immigration attorney if you think you're going to need a waiver of inadmissibility.